Hello, this is Matt Caddo with the American Kratom Association. I wanted to provide an update on three important state legislative initiatives with the Kratom Consumer Protection Act. The first will be Georgia HB 181 and the current status of that bill, which has passed and is now before the governor. And for HB 293 in Kentucky, which is in a similar position, having passed. And so it is a bill that the AK strongly favors and that hopefully will be signed by the governor shortly. And finally, HB 1229 in Maryland, which has passed the House of Representatives there and is pending action in the Senate. First, let me talk about HB 181 because this one is a very interesting history and has substantial implications for the consumer advocates and on Kratom in the state of Georgia. HB 181 was initially sponsored by Representative Townsend and was a total ban on Kratom. And he did so, and I think he did it in good faith because of constituent reports that were made to him about alleged deaths that were associated with or adverse events, including mental health breakdowns from constituents. And so they expressed their concern to him. And without much other background or research, Representative Townsend then filed the ban that would have been, of course, the seventh ban on Kratom had it been enacted. The strong response from the Kratom community obviously made it impossible for Representative Townsend to sustain or have any hope of getting a bill like that passed. The science just does not support it. But what happened next is a very interesting tutorial for us to understand what can happen when these kinds of legislative proposals are set forth. Because remember that Georgia has a Kratom Consumer Protection Act that was passed back in 2019. But the trial lawyers captured Representative Townsend. They made him their tool in order to try to implement legislation that would benefit them by creating a structure that increases the number of penalties and defendants that they can name in litigation that they have in product liability suits. And I think as I describe this, you'll see how this becomes clear about how they're capturing Representative Townsend and subsuming his interest in trying to create this new regulatory pathway that benefits only them. One of the big criticisms that Representative Townsend initially gave about the existing Kratom Consumer Protection Act is that there was no regulatory body that was assigned to actually enforce it. His claim that it was a toothless tiger. And we actually agree with that because in our efforts to try to identify a state agency back in 2019 that would be responsible for the actual regulations of the KCPA, the state agencies declined to do so. But the standards for products were important. And that's, of course, what exists in current law. When Representative Townsend went before the Judiciary Subcommittee to defend his bill, he brought all of the trial attorneys and their litigant clients in order to say how bad and how unsafe Kratom was. They touted the FDA's opposition to Kratom, saying that the FDA was claiming that Kratom was not only dangerous, but it was deadly. And they touted that experience by people, and all of their testimony focused on that kind of narrative. We fought back as hard as we could with scientists that documented that, in fact, the FDA statements were incorrect, not justified by good science, and in fact, that the FDA's narrative about Kratom was supported only by very flimsy evidence, which Dr. Joie in 2018 called embarrassingly poor evidence and data in order to support the claims that the FDA made about Kratom. Representative Townsend and his surrogate trial attorneys, and you can see them participating throughout this process, continued to prosecute the case for a KCPA. We engaged in negotiations in good faith with them, with the promise that eventually they would identify a state agency that would be included in the bill that would actually enforce the standards. And we argued that each one of these specific standards that was placed into the bill should be backed up by good science. And we were told repeatedly, oh, we'll get to that. We will work on that. There will not be a bill passed until we have identified that agency. And for the particular standards, we would look to find the scientific basis for the actual product formulation standards that were being advocated for in the bill. And it was on that promise that we agreed to allow for the bill to proceed over to the Senate, having passed the House. And the promises were clear at that point that we would be able to engage in good faith negotiations when it got to the Senate Health Committee. In fact, that did not happen. All of the negotiations were conducted by Representative Townsend and the trial attorneys behind closed doors with members of the Senate Health Committee and the Senate Rules Committee without any participation by the AKA. We tried our best to try to intervene, and we were denied. When Representative Townsend spoke before the committee, he falsely claimed that the AKA supported these changes. We had not even been asked. He claims that he was told by the trial attorneys that we supported them, but the trial attorneys knew that we, in fact, did not. This is the kind of chicanery that goes on in the legislative process, and it was egregious in this case because you have interested parties, in this case, the trial attorneys, who were trying their best to put provisions into the bill that created felony provisions for retailers who were selling Kratom products in addition to processors. And that, of course, could potentially have a chilling effect on the sales of Kratom products and the availability of Kratom to consumers if the retailers were convinced that the risks were too high because the trial attorneys clearly were targeting them in order to add them as defendants in various litigation. We were able to convince the committee that the provision that related to penalties that allowed for anyone to bring a civil action, which is the crown jewel for the trial attorneys, they at least stripped that out. But the onerous provisions that are contained in HB 181 right now are punitive. They shouldn't be there. While we agree with some of the standards that are currently in place in that bill, we do not agree that they should have allowed for the trial attorneys to have the disproportionate influence that they had on this legislation. And so what was started out by Representative Townsend as trying to protect consumers is really now the Trojan horse for the trial attorneys to have a piece of legislation that does only advantages them, allows them to expand their client list, to add defendants that they can sue, and they can have a payday. That's what this was all about. It isn't going to help Kratom consumers very much at all. And so we're hopeful that the governor will look at this and evaluate this bill for what it is. And it certainly shouldn't become law in the state of Georgia. And we should go back to the drawing board and work again with the important new information that's available. Remember that when Representative Townsend started his journey last year in the House with the filing of HB 181, he repeatedly cited the Food and Drug Administration's claims against Kratom. And even though we all could make the argument, and we did, that the scientists didn't support the FDA's position, that the FDA's position had been rejected by the Drug Enforcement Administration in 2016. It had been summarily rejected in 2018 by the Assistant Secretary for Health, and it had been rejected by an independent group of 12 scientists who are specialists in substance abuse and addiction, and that's called the Expert Committee on Drug Dependence, when the FDA went to the UN Commission on Narcotic Drugs and tried to get an international scheduling. All of this based on the arguments by the FDA that Kratom was deadly, that deaths were occurring as a result of the consumption of Kratom, and that it was a highly addictive substance. The FDA, even went so far as to say in a Federal Register document that in fact, Kratom posed a threat to the safety of the American public. Now, all of that was the predicate for Representative Townsend to jump on the FDA bandwagon. But what has happened since, which we all know, that is in December of 2023, as the Senate was beginning to take up the bill in January of 2024, we found that the FDA had explained to a federal court when they were called to present evidence and witnesses about the dangers of Kratom, they refused to do so. And the reason they refused to participate in that hearing, which would have taken place on February 8th of this year in the U.S. District Court of District of Southern California, the FDA said that they had not yet come to the determination as to whether Kratom is dangerous. That is a significant reversal of all of the claims that they had been making and the claims upon which Representative Townsend himself had relied upon. It is now no longer true. And if Representative Townsend had been listening to the science and not to the trial attorneys, then perhaps he would have been persuaded. But he was captured by the trial attorneys. Today, one of those leading trial attorneys is the single biggest contributor to Representative Townsend's campaign accounts. The Georgia Trial Attorneys Association is the second biggest contributor. He is captured by the trial attorneys, and that's very unfortunate because his good faith belief has been eroded, and in fact, the basis for it has become corrupted, and he now can no longer make any claim to being concerned about the science because now we know that the FDA wasn't willing to go under oath and provide witnesses and documents to say that kratom was dangerous or to justify any of their prior claims, which have now become invalid. We know today why, because we know that at a conference on February the 16th of 2024, the FDA scientist from the controlled substances staff revealed that the dose finding study conducted by the FDA showed that kratom was well tolerated across all dose levels in a human safety study. Now, I'll stop here and make the point. Matt Wetherington, the leading trial attorney based in Georgia, has said, oh, the FDA really doesn't draw that conclusion. He even went so far to look at a reporting system for these kinds of studies where it gives the disclaimer that none of these studies that are announced, and that's all that page did, none of these studies can be attributed to the agency, and nor are they are the conclusions to be assessed against any particular party. Well, in this particular case, it went further than that because you had an FDA official, Chad Rising, from the FDA-controlled substances staff, making a presentation about the exact findings of that human abuse potential. I'm sorry, the single ascending dose study, which is designed by the FDA, contracted to an independent contract research organization to conduct a human study. Safety was the focus of it in order to see whether or not kratom could be consumed safely by humans to allow the FDA to do their next study, which is called a human abuse potential study. The conclusion of that study was of 40 human participants, two of which in each cohort, there were 5 cohorts, 2 of which were placebo. The rest were given kratom at ascending doses. They started at 1 gram and they got up to 12 grams before 2 of the 40 participants in the study experienced nausea in ingesting 12 grams, 24 capsules of kratom in a 5-minute period. And at that point, the FDA determined that it was sufficient evidence that kratom was well tolerated across all dose levels. That's the FDA statement. That is their conclusion based on a safety study. It is the FDA's determination that kratom can be safely consumed by humans, enough so that they can now conduct a human abuse potential study, which will probably be concluded in 2 to 3 years. The significance of that statement is the conclusions that were presented by an FDA science. And notwithstanding whatever Mr. Wetherington says, it's not true for him to say that it is not something that is endorsed by the agency itself. We will have the PowerPoint presentation made by Mr. Rising on our website this week so that everyone can see it. It is an FDA document, and it can be relied upon because it accurately portrays the results of a study that is going to be very significant in determining the safe dose of kratom that can be consumed. Now, there are unanswered questions, obviously, about whether people can consume at even higher doses than 12 grams in a 5-minute period. Maybe they'll look at in the future higher levels of dose finding. But the other thing that's relevant is that other human studies have been done on kratom, which are higher doses than what were administered by the FDA in their dose finding study. And they show that at much higher levels, kratom can be consumed safely by humans. It undermines the entire premise that was endorsed by the FDA in 2016 and 2018 when they made their recommendations for scheduling. And more important, it completely undermines the claims made by Representative Townsend and by the trial attorneys in this case. And there is nothing they can say today to try to discredit that because it is, in fact, exactly what I have said, an FDA document. Mr. Wetherington likes to say to people, oh, well, what happens here is that, and if you can believe this, the FDA gives it to a pro-kratom organization. The research contract organization that accepted the bid or won the bid from the FDA has nothing to do with AKA, is not pro-kratom, and in fact is just an independent arbiter of the science. They don't care what substance is being administered to those humans. They just do it according to the protocol that was designed by the FDA. And the study results are valid and they're on the public record. And there's nothing that these trial attorneys can say, no matter how much they try to distort it or try to give you a shiny object to look at over here. It's the truth. It's really tragic that we don't seek the truth. In the same flimsy kinds of arguments made by those trial attorneys, you would think a judge would throw it out. But they may be able to trick a judge and maybe even a jury into believing the nonsense that they peddle. But this is science that is irrefutable and is on the public record today. So we're hopeful that in the exercise of review of HB 181, that Governor Kemp will review it and take a hard look at whether or not this really moves the needle, because HB 181 does not have an agency of state government which will regulate kratom in terms of the product formulation standards that are embedded in the bill, the labeling standards that are required for each of these companies to produce the kratom, which, by the way, we wholly endorse. But the only enforcement mechanism that's available under the bill, and it was admitted when specifically asked to Representative Townsend, he said, oh, it'll be the local law enforcement people that will do this. They can enforce a sale of kratom for those under the age of 21, but they have no capacity, no expertise, no testing laboratories in order to enforce against an adulterated kratom product that doesn't meet the standards that are required by HB 181. This is a shell of a bill that is designed to be one thing, that Trojan horse for trial attorneys to load up product liability cases, add defendants, Georgia companies, in order to sue them. And I don't think that's what the governor of the state of Georgia wants in terms of legislation, because it's not good legislation and it certainly should be reevaluated. And we can start again in the next legislative session, and we can actually create a bill that really will protect the citizens of Georgia. And we look forward to doing that if the governor will take the appropriate steps here. And even if he does not, we'll be back next year fighting the battle, because then we'll have even more data that will be available for legislators, and they will see how they got hoodwinked into passing a bill that really wasn't well-founded in terms of science. So we're hopeful with Georgia will go forward here. HB 293 in the state of Kentucky is a great win for kratom consumers. If signed by the governor, and we expect that it will be because the margins of passage were overwhelming, it will become the 12th state to have passed the Kratom Consumer Protection Act. Congratulations to the sponsors of that bill, Chair Moser of the Health Committee in the House, and Representative Callaway, who have been champions for the kratom consumers in Kentucky. Kentucky is plagued with one of the highest levels of opioid overdose deaths in the country, and kratom can legitimately be a harm reduction tool that will be valuable for them in the future, in addition to regulating kratom for all kratom consumers, making sure that we can clean up the industry from those adulterated products, and those products are not labeled properly. So great win for us, and we're looking forward to the governor signing that bill. In Maryland, HB 1229, and by the way, HB 293 in Kentucky did contain an amendment that I know was of some concern, and that's what's called a federal preemption provision, and it's also included in House Bill 1229 in Maryland. We have no problem with a federal preemption, which simply says that the state law will become null and void if the DEA schedules kratom or if the FDA bans kratom. Now, we know that the FDA cannot ban kratom. They only can recommend banning, but if they try to take some additional regulatory step, then they would have to justify that, and that federal preemption clause would trigger in. The bill passed in Maryland, HB 1229, with a substantial margin in the House, and it was at the hearing that we had with the Senate Finance Committee in the Maryland legislature. The testimony was compelling. You had even a family member, a father of a young man who had passed away, as it turns out, because of a combination of tianeptine and phenibut, testified against kratom. But even he said that kratom should be regulated and that he recognized that some people were benefiting from taking kratom, including his son, who benefited for a while, but then had to turn to more powerful substances, and they ultimately led to his death. These are tragic circumstances for families, and we continue to be supportive of regulations to make sure that we can, to the best that the government can do, control these adulterated products. So these three states are moving in a great direction. We expect that some of the other states that we're now and currently involved in will continue to make progress. Rhode Island, the hearing that we held before the House Corporations Committee, I thought was excellent, and the testimony provided there and the questions that were asked were substantive and I think responded to in a way that will allow for the Rhode Island House to move the bill through to the Senate. And I'm very optimistic that this year the Rhode Island Senate will be in a position to pass the bill too. That would be not only the 13th state to pass the Kratom Consumer Protection Act, but it will be a repeal of an existing ban on kratom in the state of Rhode Island. We are moving forward in North Carolina, in Pennsylvania, in Ohio, New Jersey, in Massachusetts, and in New York. Also, we're in Illinois and Louisiana and Hawaii. I know that there are, and Puerto Rico. I know that there may be some others that we're working on. In South Carolina, there was a ban bill passed, but we think that bill is effectively dead. And we've been helping to educate the legislators who were co-sponsors to that ban bill, and we've made significant progress there to convince them that next year the preferable alternative to a ban is, of course, the Kratom Consumer Protection Act. So I think we're doing well. We continue to work hard on these bills on your behalf, and we are very grateful for those kratom consumers that step up. We've got a challenge coming up in California. The kratom bill in California, in its current form, is not one that the AKA can fully support. We certainly, as a principle, support regulations, but we think that there needs to be more work done on that. We continue to negotiate on it, and we hope to get it in a form that we can be supportive of the entire bill with all of its provisions when it's finally amended. But currently, we, as a principle, endorse the regulations, but have some problems with the specific provisions of the draft bill as it is constituted. That gives you an idea of where things are. I think at a federal level, just to give you an update, it is our understanding that the FDA is now presenting to legislators in the Congress the framework for a regulatory pathway for both CBD and kratom. While they have not yet submitted a formal document that outlines what those are, at least they're starting discussions with those members' offices. And of course, we're encouraging the FDA to consider the KCPA framework. And if they want to amend it with reasonable provisions, we'll be open to that discussion as we go forward, because it's about properly regulating kratom products. The biggest concern that the FDA is telling Congress that they have is that people are self-medicating with kratom when they believe that those people should be consulting a physician rather than trying to wean off of an opioid or other dangerous substance and replacing it with kratom. We conceptually agree with that in principle, but if the FDA were truly just interested in that, why have they not acted on now the approaching 100 companies that the AKA has referred to them for prosecution with documentation for those companies that are labeling their products with a therapeutic claim, which is barred by the Food, Drug, and Cosmetic Act, and for which the FDA has a duty and obligation to refer to the Department of Justice for prosecution. Almost 100 companies and not a single prosecution. There's something wrong with that picture, and we hope that Commissioner Califf will stay true to his word that he wants to correct this problem and move forward in the future with properly regulating both CBD and kratom. So stay tuned for more information on that. We'll be having a webinar here in the next little while that will have more details on this, but I'll conclude with, again, affirming to you our commitment to continue to work hard on these issues. We will be tireless. We need your help. Every one of you that stands up with us shoulder to shoulder, your support is appreciated, it's welcomed, and it's important, because as much as we can make the policy argument, it is the constituents of these legislators whose voices they hear most loudly. And we have called upon you and you have responded. So for that, we express our gratitude and we encourage more of you to get involved as we reach out to you as we go forward. Thanks to everyone for all of the great support that you provided to the AK. We will work diligently to continue to merit that trust that you have in us. Thank you so much.